Good morning. We're going to go ahead and get started. We have quite a bit we'd like to cover with you today, and we want to thank you for coming to hear about our new borrower defense regulations. I'm Barbara Hoblitzell, and I'm here with my colleague Annmarie Weisman. We're with the Office of Post-Secondary Education and the Policy Planning and Innovation Group. As you know, the Obama administration has worked to ensure students have access to quality post-secondary education. The administration has had specific concern for students who have been defrauded by their college or whose schools have closed down, and has sought to ensure that they receive every penny of debt relief to which they are entitled, and in a manner that is fair, transparent, and efficient, with minimal burden on borrowers. That need has grown especially pressing in the wake of the collapse of the Corinthian colleges. We'll begin by reviewing the regulation that has been in place since the Borrower Defense Statute was enacted more than 20 years ago, and then provide an overview of the recent regulatory actions. The Higher Education Act gave the Secretary very broad latitude to issue regulations in this area, stating that notwithstanding any other provision of state or federal law, the Secretary shall specify in regulations which acts or omissions of an institution of higher education a borrower may assert as a defense to repayment of a loan made under this part, except that in no event may a borrower recover from the Secretary in any action arising from or relating to a loan made under this part an amount in excess of the amount such borrower has repaid on such loan. So the regulation that was promulgated to support that statute states that in any proceeding to collect on a direct loan, a borrower may assert as a defense against repayment an act or omission of the school that gives rise to a cause of action against the school under applicable state law. In July 1995, the department issued an interpretation of this regulation indicating that not all state law claims against a school would justify the rescission of a direct loan. For example, the department stated that a school's negligent failure to wipe up water in the school's hallway that results in an injury to a borrower who slips and falls on that surface would not be a legitimate reason for rescission. Nor would personal injury tort claims or actions based on allegations of sexual or racial harassment. Instead, the claim must be directly related to the loan or to the school's provision of educational services for which the loan was provided. Furthermore, the regulation does not provide a private right of action for a borrower and is not intended to create new federal rights in this area. Under the current regulation, a borrower who has a successful defense to repayment claim receives a discharge of all or part of the loan and any associated costs or fees. While the financial relief may not exceed the amount of the loan, the borrower may also be entitled to additional relief. This would include the reimbursement of prior payments the borrower made on the loan, reinstating the borrower's eligibility for additional federal student aid, and removing any derogatory information pertaining to the loan from the borrower's credit report. When a borrower's loan is discharged, the department may initiate a proceeding to require the school to repay the amount of the discharged loans when the school's act or omission resulted in the successful BD claim. Under the current regulation, the department does not initiate such a proceeding after the 3-year record retention period ends unless the school received actual notice of the claim during that period. The defense to repayment provision has rarely been used in the past. Prior to 2014, there had only been 5 instances when borrowers had brought forward a claim. The earliest instances in which the department applied the rule occurred in 1999 and involved 2 groups composed of borrowers who attended international business school. The group of some 30 borrowers obtained a judgment against the school in state court for damages for misrepresentation, which gave them a claim large enough to offset and discharge the full amount owed on their direct loans. A second, much larger group comprised of all those direct loan borrowers at IBC whom Ed IG had identified as owed a refund by IBC, which had not been paid. In that case, the department recognized the amount of the unpaid refund as a breach of contract and gave those borrowers a discharge of the portion of the loan equal to the unpaid refund and the related interest. In 2009, the department settled a lawsuit brought by FFELP borrowers and 15 direct loan borrowers who claimed as defenses to their loans acts of the school MBTI. In a comprehensive settlement, the department credited payments from the school's successor to the direct loan borrowers' obligations and applied an added reduction in settlement of their claims. However, with the collapse of the Corinthian colleges and the increase of borrower defense claims, it was determined that more robust regulations were required. A primary goal of this regulatory effort was to establish a federal standard for borrower defense claims that would facilitate more uniform treatment of borrowers. This new regulation will apply to direct loans first dispersed on or after July 1st, 2017. In addition to that primary goal, the department sought to create a regulation that was easier to understand, that provided a path to borrower defense loan discharge for all student loan borrowers, and that mapped out a process for filing and adjudicating claims. This new regulation also creates a path for FFEL and Perkins loan borrowers to receive borrower defense relief through direct consolidation loans. The regulations will ensure that borrowers with FFEL loans will have the same access to administrative forbearance as direct loan borrowers while their borrower defense claim is being evaluated, and this provision was designated for early implementation on November 1st, 2016. Similarly, FFEL borrowers with pending borrower defense claims have access to the Guarantee Agency Stop Collection provision as of November 1st. To achieve those goals, the new regulation creates a new federal standard for new loans rather than relying on state law. It creates processes for individual and group claims, establishes statutes of limitation for BD claims, provides protections for taxpayers and borrowers, creates new financial responsibility and disclosure requirements, and amends other discharge regulations that may be more appropriate for some borrowers who are seeking relief. The federal standard establishes 3 potential paths to a borrower defense: a favorable contested judgment based on state or federal law and issued by a court or administrative tribunal of competent jurisdiction related to the loan or the educational services for which the loan was made, or a breach of contractual promises between a school and its students, or a substantial misrepresentation by the school about the nature of the educational program, the nature of the financial charges, or the employability of its graduates. The regulation specifies that a borrower has a borrower defense under this element of the federal standard if the school or any of its representatives or any institution, organization, or person with whom the school has an agreement to provide educational programs or to provide marketing, advertising, recruiting, or admission services made a substantial misrepresentation that the borrower reasonably relied on to the borrower's detriment when the borrower decided to attend or to continue attending the school or decided to take out a direct loan. The final regulations state that there are no statutes of limitation for discharge of borrowers' loan balances still owed and relief based on state or federal court judgments. The statutes of limitation for borrower claims to recover payments that have already been made on loans made on or after July 1st, 2017 are 6 years for claims based on misrepresentation and breach of contract. Borrowers may file claims for the discharge of balances owed on their federal loans at any time. In addition to a process whereby an individual may file a borrower defense claim, the regulation establishes a process for groups of borrowers with common facts and claims to obtain relief. The Secretary can identify groups of borrowers from individually filed applications or from any other source of information, and can include borrowers who may not have filed an application for relief, in the event that the common facts and claims exist that apply to that group of borrowers, Where there was widespread misrepresentations, the department may presume that borrowers relied on those misrepresentations without requiring an application. Some schools have limited students' ability to sue the school for wrongdoing by requiring students to agree to pre-dispute arbitration. Corinthian had included an explicit class action waiver provision in enrollment agreements and used those provisions with mandatory pre-dispute arbitration clauses to avoid class actions and individual lawsuits by students. If a student class actions against Corinthian had been able to proceed, those actions could have compelled Corinthian to provide financial relief to the students and to change its practices while Corinthian was still a viable entity. Instead, affected Corinthian student borrowers with direct loans are now only able to obtain relief by raising the school's misconduct as a defense to their federal loans through the department's current borrower defense process, with costs borne by the taxpayer. In response to the need to address bans by post-secondary institutions on both class actions and individual lawsuits by borrowers that prevent them from having their day in court, the new regulation prohibits these pre-dispute arbitration agreements. It further prohibits schools from requiring students to first use an internal complaint process before contacting accreditors or regulators about the school's conduct. When a school enters into a post-dispute arbitration agreement with a borrower, the school must notify the secretary when the claims are filed and keep the department apprised of decisions and awards issued in arbitration and in court proceedings. In keeping with those school prohibitions, students may not enter into pre-dispute arbitration agreements with respect to a borrower defense claim. Students may agree to arbitration of their claims, but only after a dispute arises. In conjunction with the release of the final regulations, we have clarified existing regulations regarding the reinstatement of Pell Grant eligibility for students who are enrolled in closed schools. Specifically, students who attended schools that closed before they completed their program will have their Pell Grant eligibility restored without having to file an application or make a specific request to the department.
We wanted to also address part of what we regulated in the borrower defense regulation package, which was financial responsibility. Part of the financial responsibility here is, I'd say, one of the ongoing themes of the borrower defense regulations. We talk a lot about transparency, as Barbara mentioned earlier. We also talk a lot about accountability in this regulation package. And so as part of accountability, we want to make sure that we're holding schools accountable where necessary to ensure that taxpayers aren't left footing the bill for borrower defense claims. Now, I think we want to do that in a way that is fair to institutions. We also want to give them some advance warning of what we think is coming, and we'll talk about how we're doing that by some of the triggers that we're looking at coming up. The idea of triggers was really the idea of giving an early warning. We wanted to make sure that we were looking at what potential claims could be coming in. That, of course, is very difficult to do. We have, I know, at least 3 of the negotiators from the borrower defense negotiated rulemaking sessions here in the room with us. I joked with them all before we started that they're here to hold us accountable. Really, I think as we talked at the table, as we talked after the negotiations ended, one of the clear signs that we had was that we needed to do something. It's very difficult to find an early warning system that we feel is fair to institutions, fair to the department, fair to the taxpayer, fair to the borrowers. But we tried to do that. And what we tried to do was look for things that were significant enough to have an effect on an institution, typically by looking at their composite score. We had to start somewhere, so that was kind of where we went. We looked at the idea of a lot of automatic triggers initially, and we wanted to do something that would look at financial protection in a way that would protect the department, again, when those claims came in so that we had somewhere to go to recover funds. We looked at providing more automatic triggers early on. We wanted to do a little something, I think, to help people to understand what those triggers would be and why we were doing them first. So we looked at obtaining information from various sources to try to point to a risk of school closure. When we have a large-scale school closure, some students will take a transfer, some students will take a teach-out, but many will look at a closed school discharge. That also, of course, costs money to the taxpayers if the school is unable to pay those funds to the department. We also know that there's a higher risk then for borrower defense claims as well. So we wanted to deter schools from engaging in risky behavior that could lead to those types of practices in the end. And this is kind of what we came up with. We talk mostly about financial protection in terms of a letter of credit. That is not necessarily the only way. We've talked about the idea of offset, a treasury offset from funds that you would be receiving at your institution. That is something that we have in place now and rarely used, but it is an option here as well, although we typically talk about letters of credit because that's the most common mechanism that we use. The triggers would be tied to a failing composite score, either one that we've already seen or one that we project from these triggers that we're going to talk about. We have a number of automatic triggers. So we talk about debts and borrower defense-related lawsuits. These, again, could come from a variety of sources. It could be from a state attorney general's office. It could be from the CFPB, the Consumer Financial Protection Bureau, the Federal Trade Commission. It could be from other lawsuits as well. We're looking here, when we talk about other lawsuits, at those where there is a summary judgment. So not just any time somebody sues an institution, because we know that lawsuits can happen, but this is where it's gone much further than that. We're also looking at serious accreditation actions, those that would put your institution at risk, those that, again, would put borrowers and the department at risk. We're also looking at other things that we currently have in place, other mechanisms where we're already tracking an institution, with the idea, again, of reducing burden of additional reporting. We're looking at things like cohort default rates. So times where your cohort default rates are greater than 30% for 2 years in a row. We know that you don't lose eligibility until 3 years out, but we're looking again at an early warning system. So here the idea is to get something in place a year before that closure or that end of participation might happen. So we know that you still have an opportunity to improve, but we thought if you were 1 year out, that does indicate some risk, and we wanted to take some action. Similarly, with gainful employment, we're using metrics that are already in place and looking at taking action a year before you would get to the point of losing eligibility. We talked also about some items that are withdrawal of owner's equity, 90-10, and SEC actions or certain reporting events. Those would apply, those last three apply to for-profit schools only. Those are metrics that we have available only, of course, for those institutions. We also have a number of discretionary triggering events. These, in many cases, we had talked about making automatic, and then we heard some very convincing arguments about why that might not be the best plan. We wanted to have some discretion for times that perhaps it sounded like a serious event, but then when we looked into it further, it did not merit the collection of financial protection. So we talk about things that are reasonably likely to have a material adverse effect on the financial condition or your financial score. In this case, it would be things that are important, but that we might want to consider, again, taking a more wait-and-see approach. In some cases, we might want to still collect the letter of credit or other types of protection, but it's something that we want some options to do. And so some examples of those are here. We talk about failing state or other agency licensing requirements. So if you were at the point where your state is saying you're not meeting the standards for a program, that's pretty serious. And we feel that we need to take some action, but we also want to look further into what that is to make sure that we understand fully what is being said, because there is not consistency among those state licensing agencies. And we want to make sure that the event is really something that we understand and that merits the action we're taking, as well as the amount of protection we're requesting. And the same goes for the other events that we've listed here. Things like a high annual dropout rate or risks to your accreditation status, violations on a loan agreement, or one that I think is really important is pending borrower defense claims. If we see that you already have a lot of borrower defense claims piling up, that means we need to take a look at what else might be coming in the future and how many claims we might be amassing as a result of what's already in progress. And that's, again, taking information that we already have. So many of these do not require additional reporting to us, but they're more information that we're already gathering and finding increased ways to use that information in a way that's helpful to us. One of the other things that we did during this regulatory package in putting it together was looking at disclosing information to students. We had a student borrower on the negotiated rulemaking panel who talked a lot about her experience with us and talked a lot about how if she had known earlier certain things, she might have acted differently. And we wanted to make sure that we were keeping in mind those borrowers at all times. Again, talking about those themes of accountability and transparency, giving students information that they need to make choices up front is certainly better than taking information and giving it to a borrower on the back end when their decisions and choices are already made. So here we're looking at disclosing information about the triggering events that we just discussed. We really could not come to any decision about the best way to do that at this time. We had certainly a lot of lively discussion about it, but we wanted to make sure that we involve more borrower input here. And so we talked about the idea of doing a focus group to get information from borrowers, to gather that information, to see what was relevant to borrowers as opposed to just us. So we said that we would publish in a Federal Register in the future information that we found about this focus group that would be relevant to borrowers and would explain to affected schools what they needed to disclose and when, and perhaps provide some language about how to do that. We would give that information to you once those focus groups end and information is decided. Another area where we discussed a disclosure requirement was repayment rate for students. What we settled on was the idea of asking for-profit schools with a poor loan repayment outcome to indicate that warning in their materials. So you might be asking, well, what is considered a poor loan repayment outcome? And that was, again, another area where we had lively discussion. And what we settled on was looking at recent loan borrowers at the 3-year point of their loan repayment, looking at who has paid down at least a single dollar toward their principal balance. So in our opinion, that's a pretty low standard to meet. We're asking that you pay at least $1 down of your loan balance. If 50% or more of your borrowers have not paid at least $1 down, we would then require you to make a disclosure to students about these repayment outcomes. Again, more details on that are yet to come. We're still working on those details because we want to, again, do focus groups with borrowers to get a determination of what is most useful to them so that we can also save some of the burden on institutions. We will be using repayment rates as they're already used in our collection of gainful employment data. Other regulatory changes. We had a number of items on our agenda, and I think when we first started the rulemaking, we wondered if we would have enough to fill the time. As we got into the rulemaking, we saw that clearly we did. We had more than enough to discuss, and our 3 days were very full, and we ran late a couple of days, and our negotiators were kind enough to stay with us, and even on our last day, in some cases, changing flights to accommodate us. We had a very robust agenda. We had a lot of discussion about these other issues. They include expanding the types of documentation that could be used for death discharges for the FEL and direct loan and Perkins loan programs, as well as the Teach Grant when that is required to be repaid as a loan. So many people had asked, for example, about the Social Security Death Index. At this time, we're not totally comfortable with that, as we've been getting some reports of some inaccurate data, but we certainly hope that is something that we can use in the future. We will again list something in the Federal Register with a list approved by the Secretary when any of these electronic databases are approved for use for that purpose, as opposed to taking a notarized copy of a death certificate. So we're hoping to relieve some burden on the families of borrowers when a death occurs, Also, some of our partners, loan servicers, guarantors, school personnel are often trying to collect that data as well, and we think this will streamline that process quite a bit. And again, looking at relieving burden and relying on more electronic means as opposed to paper. We also outlined the restoration of the subsidized usage period for direct loan. If a loan is given a borrower defense discharge, we want to make sure we restore their eligibility similarly here to what we did with the Pell Grant program. Many of you talk about that as the 150% rule, so we would be essentially giving borrowers back their eligibility for that subsidized loan. We made some technical corrections in this package as well. We made technical corrections to the pay and the repay programs, as well as the compromise and suspension or termination of collection efforts that the department does on different debts. We clarified interest capitalization on FFEL loans. We allowed for nurse faculty loans to be used as a loan type for consolidation eligibility. And we allowed borrowers to obtain a direct loan consolidation loan if they are consolidating at least one eligible loan. And that becomes important for certain borrowers within borrower defense claims as well. Two other areas that we talked about quite a bit during this rulemaking were closed school discharge and false certification. So we're going to touch on those for just a minute as well. We want to make sure that borrowers are receiving accurate and correct information about eligibility for closed school discharges. What we've found is that many times we think borrowers are eligible for a closed school discharge, and yet they're not applying. And typically with a borrower defense application, we're getting a lot of information now on applications for that discharge, but yet sometimes borrowers are already eligible for a closed school discharge, and that is a much quicker process for us to use. We'd like them to apply more frequently for the closed school discharge if they're eligible. We'd rather them not forfeit that benefit. We've clarified with borrowers where we can that if they take a teach out or a transfer of those credits, then they are not eligible for the closed school discharge. But if they're not taking advantage of that and they're not re-enrolling in higher education, we want to make sure that they're getting that discharge. So we are doing our part to try to provide additional information. We will be sending them a loan discharge application. If we find that they are not taking advantage of the process, we will also send another application at the time that they are entering repayment, ready to make a first payment. We want the schools to clarify that borrowers can take a teach out, they can take a transfer, but they also have this option. And we want to make sure they're fully aware of all that they can do and that they can take advantage of whatever is best for that particular borrower. We also realize, though, that again, mailing addresses are not always reliable. People move. We don't always have adequate information. So we want to try to do another process that will hopefully yield more discharge approvals, which is to do a 3-year review. So 3 years after a borrower leaves a closed school, we will do a data run and try to identify borrowers who have not re-enrolled in higher education, and then we will offer them a discharge without an application. We think that's a very efficient way to do this process. Again, a borrower does not have to wait for that 3-year period. They don't have to wait for that automatic process to occur. We would want them to take advantage of it earlier, but if they don't or they're not aware, this would be another opportunity to reach out to that borrower. And that would begin, by the way, in November of 2013, so that we could start the process in November of 2016 when these rules were enacted. So we are not operationally there yet. We are working on that, and we'll have more information out on IFAP once that information is available for you. And the other one that I mentioned, again, is false certification. This is providing false certification discharge if the school has falsified the borrower's high school graduation status, if they falsified an actual high school diploma, or if they referred a borrower to another party to actually obtain a false high school diploma. We added a category here where the department can also discharge without an application anytime it has evidence that a school falsified SAP, or satisfactory academic progress. And for a shameless plug, if you'd like to know more about satisfactory academic progress, I'm presenting that section next in this very room, so you don't even have to leave. That's really convenient for you and me. So that's another area where that idea of without an application was very popular with many people at the table. We want to make this easier for borrowers. We want to make this as easy of a process as we can while still getting the information that we need. We have some resources for you already. Many of you have already probably painstakingly read through over 900 pages of regulations. If you haven't, or if you have and would like to read more, especially the details about the negotiated rulemaking process, we have our website here for you. We have notes from all of the neg-reg sessions, all kinds of issue papers out there with kind of where we started, where we got to toward the end. As, of course, you know, we did not reach consensus on the package, but we got a lot of very strong input around the table, as well as during public comment period. We received over 50,000 public comments. So I think we took your comments to heart, and we hope we've come up with something that's very helpful and explains where we landed. We also have a Dear Colleague letter out there for you on IFAP that provides some additional information, and we will continue to release additional guidance as time goes on. Here is our contact information. We are available if you have questions, especially if you think of questions when you get back to your offices, as you talk to other people. These are part of the slides that I don't know if they made it up yet on IFAP, but they will be posted if they have not been already. Barbara assures me that they are already up there, so we are available once we get back to DC by email and phone. And if you have questions, there are 2 microphones in the center, somewhat center aisle. If you don't want to stand in line and wait for a long time at a line for a microphone, you are welcome to kind of hang a little bit. I don't expect that we will go the entire session time, but we are here and available, so feel free.
It's on. Okay, good. I have a quick question around using borrower defense claims to trigger additional activity. One of the things that we've noticed is seems to be some law firms that are literally starting to chase students down. We're getting reports from students that when they go on their Facebook page, they're seeing notification from lawyers that say, contact us now, you can get all of your loans forgiven, and all you have to do is file a borrower defense claim. And that's happening more and more frequently. So I'm hoping that it's related to successful borrower defense claims rather than just a claim being made, since there seems to be some trolling for students right now. So my question is there any thought on that for institutions?
I'll let Annmarie address the trigger issue, but with regard to third parties who are trying to create sort of a cottage industry of filing borrower defense claims, that will be something we'll be watching very carefully, much in the same way that we did with those who were offering to get you into a repayment plan for a fee, or any number of other kinds of things that we see happen as people prey upon student borrowers who are feeling a lot of stress about repaying their loans. So as you become aware of those companies or those individuals who are doing that, we'd very much like to hear about them. Certainly send that information to us, and we'll be following up.
Okay, great, thank you.
Do you want to talk about the trigger?
I'm sorry, I missed that part.
Whether it's about successful borrower defense claims or just any borrower defense claim that triggers the LLC.
We're looking at the idea of successful borrower defense claims, as you mentioned, as the trigger. Certainly, if there were a large number filed, we'd want to look at that as well. But I think in terms of actually getting financial protection, the important part for us is, are we paying out? We may not have a determination about those claims yet, so I think it's always one of those things where, again, it has some discretion. If you're going to look at something that is in the pipeline and still not yet processed, we're going to look and see, do we have common reasons? Do we have something that we could foresee expanding into the future? So while I can't say we would never look at something in the pipeline, I think we're going to use a pretty good discretion there and say, is it something that we could see having an effect on your financial condition? If it's something yet unproven, we're going to use some really good caution there, because we just won't know yet at that point. But when we start to see large numbers from one school. Again, I think we're looking at exercising our group option as best we can, collapsing claims into one, applying kind of common sets of issues to one activity and one claim. So we really want to look at that very carefully. We can't give you a definitive absolutely never, but I think we'll give a lot more emphasis to ones that are already processed and approved, giving some real caution to those that are still being worked on.
Thank you.
Sally?
Hi. So my concern, I guess, is how many of these triggers are going to financially put somebody possibly out of business? And let me give you an example. You have somebody that has weak financials, so they already have to put up a letter of credit. That's one of the requirements. And because they have weak financials, that's always also an issue with the accrediting agency. So now they have an accrediting agency issue, which is the same, but maybe they have some other issue that wouldn't put them out of business, but might be something accrediting needs to have corrected. And then they end up in a GE situation where they already have failed and probably will fail next year because of the numbers already being out, and maybe they can't appeal or don't have. And I'll basically use one I deal a lot with is cosmetology, because those are people that don't always report all their income, so that's part of the issue. But how many of these, are these stackable? Is it going to be a letter of credit, several letters of credit? Do we have any idea?
They are stackable. I think, though, what I would say is we're looking at them in a group. So we're looking at the behavior, and if we can say that the accreditation action is a result of strictly that financial situation, and we're already getting something because of their score, we're already getting protection in an LLC because of the score, we're not going to hit you twice because you have the same activity causing that trigger. So if it appears to be two triggers, but it's really the same facts, then it's one trigger.
Okay.
And I think that's part of why we really landed on the idea of making these more discretionary, because originally we said automatic, 10% for each thing. We don't really have to think about it much. It's very fair because it's always going to be the same. This is 10%, this happens, it's another 10, that makes 20. What we realized, though, is that that kind of thing could happen. And again, we thank the negotiators because they were very instrumental in having that kind of a discussion with us and engaging us in that dialogue. We really want to make sure that we're not doing harm here. We're not out to get schools. We want to make sure that we're getting protection where we feel it's needed. And I think that's a really important distinction. We're not trying to penalize anybody by saying, you were bad, we're collecting an LOC. That is not the intent. The intent is to say, a situation occurred, we feel that it's risky, we feel that it's going to affect something in a way that could be very negative, it could lead to behaviors that mean students have claims that cost money that we can't then collect on later. We want to get that protection up front, so we're looking at it as protection for the taxpayer and protection for the borrowers, and not to be punitive in any way.
Thank you.
Thank you.
Hi, my question is on the repayment rates. You know, you made a statement about a focus group is going to be looking at that. Are you really going to focus on the income-driven repayment plans where you have a large section of borrowers who are in income-driven repayment plans who are not paying down the principal during their repayment plan? Even though this administration is really pushing income-driven repayment plans, why should it become a negative when the borrower is on an income-driven repayment plan?
And that was something that, I thank you for that question, because it is something that we wrestled with nearly endlessly and right up until the end. It's something that we value. We want people to be in the income-driven repayment plan so that they're getting an affordable repayment option for themselves. We also, though, think that in those plans, you're typically going to be paying something. You've borrowed money, and so we're looking 3 years out, and we're saying pay down $1 of principal. Pay down $1 toward that loan to reduce your balance. We think that even in those plans, typically a borrower would do that. And so, again, we feel that we've set the bar at a place that's appropriate by saying 50%. So we're not requiring that warning until you have 50% or more of your borrowers not paying down at least that dollar. I think we tried to get at a place where we felt comfortable that that was reasonable given the push for income-driven repayment plans.
But, you know, when you're looking at, like, say, a population of students that are in, let's say, a criminal justice program or a nursing program, single parent, 2 children, living in a family size of 4, supporting that extended family 50%, that payment is basically zero, okay? The payment's going to be zero. So they're not paying down the principal.
Correct. And so when you have more than 50% of your students who are in a circumstance where they are not earning a sufficient income to service their debt, that is something that we want people to be aware of when they're selecting the school.
Well, again,
That is a reasonable warning.
You're saying not earning a sufficient income. They could be earning a sufficient income, but remember, you have to take family size into that matter also.
Absolutely. Family
You're not
size and
looking,
state.
you know, you're looking at a family, maybe a single parent with 2 children and living with her parent, okay, that she's supporting 50% of that. So you have to look at that whole.
Absolutely. But again, if you have more than 50% of your students who are in that circumstance, that should be a reasonable thing for prospective students to consider.
Okay, thank you.
Hi, I was hoping that you could provide a little bit more clarification on what some legitimate claims would be in borrower defense. And the reason I ask this is because our school sat in on a webinar with our legal counsel. The webinar was provided by a law firm. The information that was provided was a little bit scary because they indicated that even puffery could be a reason for a student to provide a claim. They gave the example of a student ambassador giving a tour and saying, our nursing school is the best nursing school in the state and our students get great jobs. And so the student chooses to attend our school because that information is given and feel that their experience was not the best experience they could get, or they don't get a great job. Is that really a legitimate claim that could be made?
We love puffery. We spent a lot of time talking about puffery. So no, in the specific example you gave, the fact that a tour guide said this is, you know, the greatest school ever and you're going to just love it, that is not a claim being made necessarily to the detriment of the student who decides to attend. The student would need to be able to demonstrate that that statement in and of itself was the thing that caused them to decide, this is where I'm going to go, this is why I'm going to take out this student loan, and then to not have benefited at all from that education. So, you know, there really is a calculus involved in terms of determining, was the misrepresentation substantial? Did it cause harm? Was the student injured, basically, as a result of having taken in that information and having based their decision on that information?
So what sort of documentation would a student have to provide to demonstrate that?
It'll vary, and these are all very individual cases. So, for example, one thing we can cite now that we know, because again, this is a very new process and the regulation won't take effect until July 1st, 2017, but under our current regulation, students who attended the healed colleges were able to base misrepresentation claims, in some cases based on placement rates that had been misrepresented, that shared with them that more students were going to be placed in jobs upon completion of those programs than was factual. And those students were able to cite that they looked at that website, they saw those placement rates, they made the determination to enroll in that program because they felt confident they would get a job, only to later find that those were inaccurate placement rates. And they were materially inaccurate. It wasn't like a difference between 88 and 90%.
Okay, thank you.
Sure.
Peter Layton, Richard Layton. I have 2 questions related to the discretionary triggers for letters of credit. And I appreciate the comment that you're not trying to penalize or harm the institution in the analysis. So my questions are, one, do you envision, or is there going to be a plan to actually communicate with the institution about about the thoughts before they happen, and not simply to send the letter asking for the letter of credit? And secondly, who is really going to be making these decisions? Is it going to be at the team level? Is it going to be in DC? Can you elaborate on that?
In terms of the communication about the discretionary triggers, I think much of it will depend on the source of the information. I think it will depend on the type of information, if we need more information. It may be that the first time a school hears about it is when we're requesting the letter of credit. Keep in mind that just as we do now for requests for letters of credit, if a school is confused by the letter, if they don't understand the request, if they need more information, they can always get that information by calling the person whose name is at the bottom of the letter. And I would envision a similar process. That those details have not yet been worked out. We would expect that it would also be handled at the team level in a very similar way to how letters of credit requests are made now, and make use of that process in the regional offices as opposed to in DC.
Is there going to be a special borrower defense unit in DC?
There is a borrower defense unit. However, this type of work in terms of the letter of credit, that type of process, we are not certain where that will be handled yet, but we would expect that that would still be part of the regional process that we have now.
Thank you.
Hi, I have a follow-up question about the repayment rates. When my colleague asked a question about the 50% threshold, you actually made a judgment with your answer, and you said, you know, if a school has less than 50% of their borrowers, not paying down at least $1, students should know that. So the thing is, you have to understand that in New York State, there's a fabulous state program called the Get On Your Feet program, where the state will service your loan for the first 2 years as long as you opt for one of those plans. So what you've created with this regulation is a scenario where a financially savvy borrower will opt for that plan in order to get the benefit that New York State offers. At a for-profit institution, if the repayment rate then falls below 50%, the school will have to place a warning. In your mind, that's a good thing because the student should know that. Now they go next door to a nonprofit institution that's not subject to this sector-specific warning, and the repayment rate could be even lower. So how do you justify that?
We're using the same repayment rate warning that we use in gainful employment. And we find that based on the data we have available to us at this time, the schools that are most likely to have an alarmingly high, or alarmingly low rather, repayment rate tend to be proprietary career training schools. So that was how we determined that that was the population where we would use this specific disclosure. It's based on the evidence. I'm not sure I entirely understand the issue with the New York program. It sounds as if the New York program is actually paying down the student's loan.
No,
Is that correct?
but the student has to opt for the plans where very little principal is repaid. So what you have is, instead of it being a student-based conclusion, where a student says, do I want to do it, there's this fabulous program in the state that's driving large numbers into it. And because the warning only applies to one sector, even though you think you have strong logic with this, you could be sending a student from one institution that actually has a higher repayment to another because the warning only applies to one type of institution.
We'll take
So
that
it's just
back.
something, New York State is a big state, and a lot of students are opting for this. It's something that I want you to be aware of.
We'll take that back.
Thank you.
Hi. A question that I have, all accrediting agencies tend to use slightly different formulas when coming up with your completion rate, your licensure rate, and employment rate. And a school could complete its calculation according to its accreditation standards, publish those numbers, and a student, now that we have borrower-based defense, may file a claim stating, I didn't learn, or, you reported that you have a 100% licensure rate, but with our accrediting agency, that 100% licensure rate is based on the number of students who actually complete the program. So a student looking at it at the surface level, it looks very, very high, but that number is really subject to interpretation. So my question is there anything structurally schools can do to prepare for students making this claim? Because my school, our schools are in Louisiana, and we're already seeing students coming in that have been approached by attorneys to make this, to make these claims. So are there any things that schools can do to kind of hardwire in, where we've provided the education, or things that we can kind of look for that students may pose?
Let me see if I can restate your question and make sure I'm answering what you're asking. So you're saying that because students can access information about your program in multiple places that may not be consistent with your message, that you want to be able to do something at your school to assure that there's definitive factual information available to your prospective and continuing students?
That is correct, because the information that is pulled, let's say on the College Navigator, it's pulled from your iPad's report. Well, that's separate from the information that's produced maybe by your annual report that you give to the accrediting agency. And if an attorney is just looking for vast numbers or difference in your completion rate, boom, there it is. It is just because the two are not synced. And because they're not synced, a student may not go to the College Navigator website, but they may go there once they're disgruntled because they don't feel that they receive the education that they're due. And that's a very, you can look at any school in America, and likely, definitely private schools, your proprietary schools, you're gonna see big differences between your completion rate and those numbers.
Sure. So if the data are accurate in the format that they're being presented, so for example, someone's using a different calculus in order to say the licensure passage rate is based on people who complete the program versus someone who else is calculating it based on the number of students who enter the program. We would look at that. The enforcement unit, the borrower defense team, when they're adjudicating these claims, will make a thorough analysis of not just the students' assertions, but the actual facts of the circumstance, and make a reasoned determination. It's no different than any other type of consumer protection claim where somebody may allege something, there have to be facts behind it, and there has to be an analysis of those circumstances.
And are there any guidelines for schools to just, basically prepare, like are these, if you are a cosmetology school, here are some of, because you all hear the claims, so it would be great if we could kind of work to prevent the claims by at least knowing, hey, these are our top 10, this is what we see. Schools, maybe you should take this guidance to prevent these type of claims.
I would suspect that over time that will occur much in the same way we do top audit findings, top program review findings. We simply don't have enough experience in this arena to make that sort of assertion. We've been very forthcoming with regard to what's been happening with the Corinthian claims and have published several reports, 3 from the special master, a more recent one recently from the enforcement unit, that detail all of the circumstances under which claims have been received and claims have been decided. We'll continue to be transparent on that, but at this point we don't have a lot to share.
Okay. Thank you so much.
Sure.
My question is, do schools need to reevaluate, or will further guidance come out on extending the requirements for record keeping for various departments? Because if students have no statute of limitations, we're not going to have any records to show what we did or prove that we did what we were supposed to do.
So yeah, we spent a lot of time talking about this. So the 3-year record retention limitation that exists in the current reg is really a derivative of the 3-year record retention limit for financial aid records. What we're seeing in regard to borrower defense is that very few of these claims are substantiated based on financial aid records. It tends to be things like enrollment or admissions or marketing or other kinds of things that are not, that would have never fallen into that 3-year record retention anyway. Technology is becoming much more sophisticated in terms of how far back one can go into somebody's website and see prior publications. But the borrower who is also bringing forward the claim is going to have to submit evidence to substantiate the assertion they're making.
Thank you.
Hello, I have a couple of questions. So at my campus, communication is number one. It's so awesome. I know everything that is happening. Yeah, right. So my first question is, how and who are you going to tell the institutions that they have to start notifying the borrowers, the students in your marketing material? When are you going to tell us? Because if we have marketing material made July 1, 2017, do we have to stop using that material and have it printed? And then if we have to notify borrowers and we get out of the trigger zones, do we have to continue another year to notify them or not? So three questions.
These are all questions that I'll say are to be determined.
Really?
They will be
That's
published.
not acceptable.
Well, that's the best we can do right now because we don't have the requirements in place yet for those triggers. As we mentioned earlier, these are things that we want to focus group so that we can get the best information that will be most useful to borrowers.
So when I go back to my campus and I tell my president this, because he's going to look to me for answers, and I'm going to say they don't know and direct him to you.
At this point,
Yeah.
yes, because
Okay.
we will publish in a federal register when that requirement is made with the details of what the disclosures need to be. I don't know yet if we'll dictate text to you or if we'll give you generalities about the topics that it needs to address. None of those decisions have been made at this time. So we want to go out and do focus groups with the borrowers so that we can get the most meaningful information to tell you to give to them.
Okay, thank you.
We'll come up here first and then back to Colleen.
You spoke about the adjudication process, and I have great faith that the powers at the Department of Education will be using logic and will be fairly evaluating borrower defense claims. Will feedback be provided, though, to the schools, allowing them to present their information in these cases? Question number one. Because as we evaluate incoming financial aid applications and we go through verification and see conflict resolution, you'd be surprised how many people don't tell the truth. So we would hope that the same level of scrutiny, evaluation, expertise would be in play when these borrower defenses come through for due process.
I can absolutely assure you that will occur, and that due process was a very significant concern for us. And there is a substantial role for schools in this process.
Thank you.
Colleen?
Hi, my name is Colleen Russo. I work for ECM. We're a third-party servicer. I'd like to start out by thanking you guys very much for giving me something to do with all my free time in the last several months. That's been very helpful. Before I ask my question, I just wanted to quickly follow up on what the lady was just saying in front of us. I think you guys have done a tremendous presentation today, and I can hear in your voice and in your heart that what you have put down on paper and the way that you believe it's going to be carried out are very consistent, and that you truly are not, out to get schools and so forth. My fear is, especially since my financial aid world has been rocked this week by the impending retirement of Jeff Baker, is that you ladies are not always going to be at the department. There's going to be people that come along that have interpretations, and the regulatory package, it doesn't speak to, you use the word material, it really doesn't speak to materiality. It doesn't people are scared because there's one thing in the regs and we hear you saying something different, but how do we know how these things are going to be adjudicated?
First of all, I'd like to thank you for your comment, and I'd like to thank all of you for coming to the session. I hear many people talking about going to other training events, and I always encourage people to attend training events. I think training is wonderful. Knowledge is information. Information is power. That's all good. It's all really good stuff. I get nervous sometimes, though, when I hear people say, I went to this training session and now I'm scared. We're not looking to scare anyone. Yes, we're looking to reassure you. Yes, we're looking to say that we're certainly sad Jeff Baker's leaving too, but we don't have plans to go anywhere. We expect to stay. I wish I were as close to retirement as Jeff Baker some days, but I'm not. So I think our goal is to provide to you information that will carry you forward and to assure you that we do expect to be here. And we see the vision of the department as a whole, and I've seen it now from that perspective for about 10 years. The 10 years prior to that spent at the institution side. So as I used to tell my daughter a lot, I was you. I know how it feels, and I carry that with me every day. I bring that with me to work. I don't want to ever forget what it's like to be you, because I think that's a really key part to keep with you, and to remember what it feels like to be the one who was scared and to feel like you had no one to call or you had no one who understood. That's really important to me. That's something that is a significant value for me. And I can't promise you I know exactly what the future looks like. I can only promise you that I will not forget what it feels like to be on your side of things, and that I will remember what that feeling is, and that I will try to be here to reassure you when you're scared and when you feel that what we're saying is a little different than what you're seeing in the regulations. I think it's hard to express in regulatory language some of the feelings that we have, but as you see it executed, we look forward to your feedback and we look forward to working with you as partners and to bring out something that is the best for the borrower, the best for the taxpayer, the best for the schools and the department as we all work together. And I hope that you'll trust us with that. I know that's really, really hard to ask for and hard to give. I get that. I really do. But I hope that our word means something and that you will continue to work with us as we work with you.
Thank you, Annmarie. Very quickly, and I'll sit down, the breach of contract issue. Could you elaborate a little bit on, essentially what is a contract? Traditionally, I think we are used to, dealing with the enrollment agreement as the ultimate contract. As I read through the regulations, it strikes me that, we may be held to a contractual agreement in, a catalog, in a brochure, et cetera, et cetera. So if you could expound.
You have interpreted that correctly. So a breach of contract definitely extends beyond a formal enrollment agreement. It will include other kinds of published materials that you provide to students that make assertions around what they will receive from you.
If I recall correctly, you said that financial stress an institution might have is a trigger and could require a 10% line of credit. Is there any other kind of remedy that could be available to a school? Because financial stress, a school that's under financial stress may not be able to come up with a 10% line of credit, and then you're exacerbating a bad situation, and potentially the line of credit could put the school out of business.
We talked with some surety bond agents. They do not currently have a product that meets the needs that we have. When we talk about a letter of credit, and I don't want to get too far into the weeds of those issues, but we require an irrevocable letter of credit. It's something that you provide to us to say it's for this amount of money, and you as the person who's requesting it can't take it back. It's valid up through a certain date that we specify. And we can call it in at any time and get those, that amount of money or any amount under that. the idea of a surety bond is attractive to many people because they feel it's something that's more affordable than a letter of credit. It doesn't tie up their assets in the same way. There's various advantages to it. At this point, we've not yet seen a product that meets those needs that would be kind of the equivalent, but we're open to that idea in the future, and I feel that we've worded the regulations in a way that allow for that in the future if something is developed. We met with people who issue bonds, a couple of different places, and they are thinking about whether there might be a product in the future that could meet those needs. And we would certainly entertain that option in the future if they come up with something that works. The other issue that we talked about was an offset. So essentially holding back a percentage of the funds that you would be receiving in disbursements to make up for not getting a letter of credit. And again, we have that option available now. It's something that we can do operationally, don't typically do, but again, if we required surety and a school said, I'm not interested in a letter of credit, I'd like to try this offset idea, we could work with you to set that up. It's something that, again, because of the language, the way it's worded, we can operationally do it, so it's an available option if that's better for an institution.
What about reimbursement?
We haven't really discussed the idea of using reimbursement in that way. I'm not sure if that would really be covered under the regulations, but I think, again, if it's something that a school is interested in, they could certainly ask for that and we could look at it.
Thank you.
But I'm not sure, just thinking at it quickly, and I know we debated it endlessly, but I'm not sure that ever really came up as an option because the concern is that there's not enough then for us to retain in terms of the amount of potential claims. I'm not sure we'd be holding enough back to give us the protection that we'd feel like we needed. But again, depending on the amount, I can't absolutely rule it out either.
Okay, thank you.
Thank you.
Thank you for being here. So to stay ahead of the lawyers, which seems to be an issue, and to provide some sense of security for the scared people, and have you thought about like benchmarking and taking the focus group ideas and what's going to happen and maybe, okay, this is what our rules are going to be, and let's go see if we can back check them and look at like ITT Tech, how it went down. I mean, the Corinthian example, I guess you have out there, lots of literature about that, but if you went back in history and had these rules in place, would we have seen ITT Tech, or would we have seen the Trump real estate guys being an issue as a way of making your strength of what your rules are going to be actually work?
So we have done some analysis, specifically around Corinthian, because it was the real-time example when this regulation was being developed. And we did spend a significant amount of time looking at, especially the triggers and some of the other elements, to determine whether or not these would have resulted in warnings early enough for us to have taken action that would have had a different outcome.
So I work at a large university, and we have a lot of different schools, departments. Everyone's putting out their own literature, their faculty are putting out their own literature. So how do we control for that, or how do we, I guess, prevent people from misstating on one end and sort of, does all communication have to go through our general counsel now? Like, how do we go about that?
Yeah, I wish I had a really good answer for you. That is a challenge on a large university campus. There's a lot of moving parts and a lot of people who are taking ownership of communicating various things. The best advice I can give you is certainly to make sure that the senior leadership on your campus is aware of this regulation, is aware of the consequences, and conveys that information to all of the deans and directors and everyone else who's out there putting out information about how fabulous your school is.
I was interested in the conversation during the rulemaking about this topic of what's going to be a contract for purposes of determining if it's been breached. And I wondered if any other sectors had arisen in the discussion of how they handle that, like pharmaceuticals, where they have the smiling people, right, on the horizon, and then they have 2 pages of really tiny type. I mean, did you talk about that, of like ways that marketing and technical, you know, I don't know what you call it, presentation, what some of the models were that you were thinking that you might see emerge?
We really haven't done a deep dive into
Okay.
that at this point. I mean, I think that generally you would look at a reasonableness standard. What would, you know, a reasonable individual infer from the marketing information in front of them?
Okay, reasonable actor. Okay,
Yeah.
thank you.
I hope you have time for one more question. I work in a community that's been profoundly affected by both the Corinthian and the ITT closures. And I work at a college access center where I'm dealing with students who are applying for closed school discharges. Some of them ask me, what's a comparable program of study? Could you elaborate on that at all?
We don't have a regulatory definition of comparable program of study, and you get enough people in the room, and of course, everybody has their opinion, right? So we talked a lot about that, and really the issue becomes, are people able to use their credits? Are you able to go somewhere else, enroll in a similar program? People have talked about zip codes, they've talked about other ways that we might look at that. And I don't think we want to be too restrictive here, and I don't think we want to be too prescriptive either. We want to be flexible, but if you're saying that you were at a nursing school and you were in a nursing program, and you go to another nursing program across town, that one's fairly easy to define. Yes, that's probably a comparable program. But then, of course, there's a difference. Are you looking at an LPN program versus an RN program? Those are not necessarily comparable. Is someone able to take a similar diploma, certificate, degree, and go somewhere else and get similar types of, I'll say, a length of the program, similar types of content? Certain programs focus on other more, I'll say, narrow issues. You might be going to a program that focuses on one thing and the program across town doesn't. And that focus might have been very important to you. So we ask borrowers to really make that determination and look at, are you able to enroll in a comparable program or not? And again, looking at the credits that maybe could be transferred in, what is available to them? And we can certainly help them with that application if they have questions, but really just using their best judgment to say, are they able to get into a program using credits that they've earned to apply to another program somewhere else?
So for instance, if they're going from an ITT to a community college, there is a good chance that perhaps none of their credits was going to transfer because the community college is not going to take the credits from ITT and transfer them equally because of different
Right.
accreditations and things. But that might be a reason that they needed to contact you further then.
Right.
My second question is, if someone has their loan discharged, we mentioned a 3-year automatic time frame, they haven't re-enrolled. Is there a time frame which says, we're going to discharge, you can't go back to school for another year, or you can just start all over again?
No, we're not restricting the credits in that way. We ask them at the time of the application if they're actually filling out a paper application themselves, and we say, have you used these credits, essentially? And if they've used the credits, if they've transferred, if they've been part of a teach-out, then they're not eligible for the closed school discharge. If they find that they can use, 3 credits later, we're not taking back the discharge. It's not that kind of a system.
Thank you.
So I think the intent is really good to say, were you able to use them, weren't you? We talk with a lot of different sources about how long credits are typically usable, for lack of a better words. Many times when students are in certificate programs, people say after a year or so, they're not going to be able to transfer the credits, regardless of where they're trying to transfer them. People, if they're in a more hands-on type of profession or preparatory program, they want those credits to be fairly new. And if you get too far out, they're going to need to repeat them. So we're not going and saying, okay, you've gotten a discharge, never ever use those credits. They might be surprised and find out they can use a couple of them, and that's fine.
Thank you. I appreciate your flexibility, and for one, I'm less scared.
Thank you for your work. Okay, I'm going to put in another shameless plug. I have another session in this room. You have great seats already. You're welcome to stay. We have a break in between, but thank you very much for attending if you're not staying.